Good morning, everyone. Welcome to the Bleach Demon channel. Forgive the absolute fit that the reactive is having because it's, I don't know, apparently having a stroke or something. Don't know. We'll just turn that off for now. I've also got a trim on board here, so he'll be cooking in the background, lurking, I don't know. So, yeah, we're going to go cover for roughly an hour the oral arguments of the Virginia Supreme Court hearing the arguments against the gerrymandering, which, if you'd watched Sultans the other day, yeah, it's basically an unconstitutional wad of crap. And there's no reason for this to stand. It's not a matter of whether or not they should have done it. They can't do it. And it's less about the outcome and more about the process, as far as I'm concerned. So,
I mean, it's just a bunch of liars doing liar things anyway, so well, it's nothing new there.
It's worse than that. I mean, they blatantly violated the Virginia Constitution.
Yeah.
And I think
Doesn't that kind of make them traitors or criminals at best?
At best. I mean, of course it'll be, oh, well, you can't say that. Well, I just did. Yeah, this is just something where they've gone out of their way to cherry pick, and innocent people suffer. We talked about the maps.
Yep.
We'll go back to the when you've got, and yes, this is just a political cartoon, but when you have certain areas just all like 5 districts, I think we counted, that are all dominated by the same DC elite, that's not fair. That's not proper representation. That's some of the worst gerrymandering outside of Illinois.
Yeah, that setup is just made just to screw everyone over who isn't part of the team.
Yep. Yeah, that's
because
really it.
Being free and fair, right?
And well, I mean,
free and fair.
And we went over the language of it, and it also violated the clear English requirement that is made for, not just constitutional amendments in the state of Virginia, but also for any referendum.
Yep.
So, yeah, so there's... oh, let's check on the stream health. So, to answer Kingdom's question, it's something where it could go to the United States Supreme Court. I think it's unlikely, because this is kind of an internal thing, but if it is something where it affects voter rights, it possibly could. And I mean, yeah, it's just complete and utter chaos all around.
Yeah.
So while we're waiting for the...
if it goes to the Supreme Court, I'm sorry for interrupting, but if this goes to the Supreme Court, how high are the chances of this actually getting fixed properly, or have the Supreme Courts been stacked against the common man?
Well, in the Commonwealth of Virginia, we actually, one thing I was thinking about was going through and looking at the Virginia Supreme Court judges, just to point out a few things, if see a little bit about their background. And
okay, now you're gonna get a stupid thing from me. I didn't know each state had a Supreme Court. I thought the Supreme Court itself was like supreme all over the country.
No.
I thought it was a difference between the courts.
So there is the, each state has its own Supreme Court. And then because you have federal and state crimes, and so you have to have 2 separate court systems. That's just the way we set it up. Yeah, it's maybe a little extra redundant at times, but I don't think it's a bad thing, because a lot of stuff should be handled at the state level rather than becoming a federal issue. And that also
Mm-hmm.
really pertains to if, say, California does something just actually batshit crazy, like always. Um,
Yeah.
then you have a normal state like, I don't know, let's say Missouri.
Mm-hmm.
What, if it went to a federal case, then what would happen? It'd be a blanket a blanket ruling across the entire country. But if it goes to state supreme courts, it only affects that state. So,
Oh, I gotcha. So so I thought the Supreme Court basically was the federal court.
well,
My bad.
no, it's just like, you wouldn't, you don't know, so I'm not going to hold that against you. It's just more of a, oh, yeah, these are two very different things. Yeah, and
Mm-hmm.
because of different reasons, and it goes back to um a lot of how the United States got set up because we wanted the states to have supremacy over the federal government. So
Mm-hmm.
it's kind of a big
As it
deal.
should be, to be honest.
So we will pop in, see if they're still waiting to kick it off. I'm not surprised. Judges are never early. They're always on judge time. And we'll just
Yeah.
hit a refresh just to be sure. And
What even is a judge time? It is whenever they can put the finger out of their butts.
yeah, pretty much. So we'll go over and just look at a little bit of the history of the Supreme Court of Virginia, just so you get educated. So it's actually this is technically one of the oldest courts in North America.
Really?
Yep. So as part of the 1606 Jamestown Charter, it was established initially in 1606, and then the 1623 we had an appellate court. So you have the Supreme Court, the appellate court, and then the local jurisdictional courts, which that gets into you've got criminal, you've got civil, you've got family courts. So lots of layers to this, which I think is a good thing typically. So then the current one was under the General Assembly. So when the Commonwealth was independent during the Revolution, but during this period, so 1779, there were 4 superior courts and then a Supreme Court. So you've got kind of local circuit, and appellate, and then Supreme. It's been a while since I've sat through legal classes on all this. So, but yeah, so we can there's all this bullshit. So right now we can go and look at the active justices. So we've got Chief Justice Cleo Powell, D. Arthur Kinsey, McCullough, Chafin, Wesley Jr.
McCullough?
Yeah. Not McAuliffe.
That was okay. That sounded fucking weird.
Yeah, sorry. Yeah. And then, so we've got, we'll go in because who appointed who is kind of important. And this is or can be a lifetime position. So let's see. Yep. So Cleo Powell was appointed by now Senator, then Governor Tim Kaine. So, Democrat.
Of course.
D. Arthur Kelsey, appointed by now Senator, then Governor Mark Warner. Are you starting to notice a trend?
Yeah, seems a bit more rigged every moment.
Nope. Stephen McCullough, former Attorney General. Let's see. Who appointed him? I'm trying to. Was in.
Oh wait, I thought it was a woman's name.
No, not Stephanie. Stephen.
No, no, I thought them McCall or whatever it was a woman's name.
Nope.
I thought that was the first name. Sorry, I thought Steven was the last name.
Wait, born in Marseille. The hell? 2011. So that I'm trying to remember who was. Let's see. Public Council. All right. So he. I can't remember who he would have been appointed by. That's kind of that could be important. So he could be he could be a Republican leaning. I don't know.
Yeah.
2016. So, I'm not sure.
One thing I don't like about these judges is you can already tell what they're gonna do based upon who they were appointed by. The
Yes.
factionalism is it's politics in law is some of the worst fucking things in existence.
Oh yeah, it's activist judges are not a good thing unless it's like activist judges that help the left apparently. So McCullough was put in by the General Assembly. Okay, so that's a mixed bag. I'd have to look back at the composition in 2016. So
he might be a nepo baby, but he might also be one of the few people in there through merit. Then
correct, yeah. It's hard to say exactly. I don't follow this terribly closely. I should obviously. And all right. So.
Well, you're following it closer than me, so I'm not gonna start pointing fingers.
Yes, but you're Norwegian. You shouldn't have to follow my state's absolute tardation. Just saying.
Law is law in at least a theoretically civilized society.
Yep.
I wish I knew what that was like.
Let's see. Yep. Let's see. Who else do we have? Teresa M. Chafin, Russell County. So she's like from. Is that Southwest Virginia? Yeah, down near Tazewell. Interestingly enough, the circuit court judge who has put all of this in motion. And
so, first woman judge, and already we can start noticing patterns.
I mean, not the first, but there's always a pattern. But again, if she's from
first one we know, first one we see, basically, it's what I mean.
Well, yeah. And so she was put in by the assembly as well in 2019. So
right.
That I'm trying to remember. Yeah. Let's see. And then also picked by the Virginia Assembly in 2022. So this was under Youngkin. So more likely to be. So Youngkin was the now former Republican governor who did a lot of good for the state.
Oh, that's good.
So hopefully
Don't trust any politicians, but if you have to deal with someone, do the Republicans before you deal with the Democrats.
Yeah. They'll only stab you in the back, but so much.
Yes.
And then, oh dear Lord. Oh, from New York City. Well, that explains it.
Well, they're fucked.
Yep.
That's fucked already.
Let's see. Elected to the General Assembly in 2022. speaks frequently about domestic violence, attorney ethics, evidence, courtroom etiquette, and effective advocacy. Yeah, but he was in Fairfax, so
The main question here is he a freaking hypocrite or does he actually have a point?
I don't
I want
know.
to wager that he's a hypocrite.
I mean, I'm just looking at the glasses and the fact that he's from Fairfax, so yeah. And now we
What are you
have,
talking about? He's in New York? That's a bad thing, sir.
yeah. And now we have Junius P. Fulton III.
That was a mouthful of a name.
Yes. Yes, indeed.
Thomas Mann.
And then he was put in January 1st, 2026.
Right.
So, yeah, but that would have been, I don't know, that could have been anybody at that point. But yes, so we will see absolutely nothing. Oh, here we go. So there's no video, just the oral arguments.
Right.
Which I need to repipe the audio.
Yep. Do you mind sharing the screen so I can hear it? Because if not, I have to use the video
Yeah, yeah.
on the
Give me a sec. I've got a
version
lot
that
of
I
things
hear
going
us.
on, Trim.
That's okay. Juggle the tech. Thank you, sir. Let's see.
If chat could confirm if the audio is piping through. Nope. Okay, there's no audio right now.
Hmm.
Oh, good. Thank you. Thank you, Kingdom. That's an interesting point. Yeah, it's not like you're going to go to the newspapers like they used to for legal
Nope.
notices.
You can get it to your phone directly these days.
Hmm. Okay, yeah. So that was an interesting bit of an argument that illegal notices have not been properly adapted to the current world and current circumstance, which
Mm-hmm.
I think that's a fair argument. I mean, you can say that's a fair argument either way of this. But the bigger point of this, basically being done incorrectly.
Yeah.
Oh boy, this is going to be pedantic.
So legal speak, blah blah blah. Then I suppose.
Yeah. Oh God.
Yeah, you said it was gonna get pedantic.
Yep.
At this point, if I was there, you would just hear a loud fucking groan from me.
I just did.
Jesus fucking. Now I understand why you had grammar Nazis in YouTube comment
Yep.
sections being like, "Oh, this, that."
Ah, all right. Sorry, LGM. All right. I'll mess with this in the background.
Oh boy.
Oh wow.
Oh, a mere October surprise.
There we
So they
go.
seem to be
Might
suggesting
get a
that
little
there's an
double
importance
audio
difference
from Prim, but I
and
can handle that.
a tough challenge to
Sorry.
figure out what the standard would be for that. But I would have trouble figuring out something that's more important than the death of the candidate you voted for.
What is your position, your client's position, regarding a constitutional amendment that is adopted at 6 p.m. on election day?
Okay, guys, does
with an
that
hour left
work
in
better?
polls? Is that the next general? Is
thought
that
we had it
still the next
fixed.
general election? Because hey, you could have waited until
I get this
6:59
right,
to go
Bleach.
to the
Does this
polls to
mean
vote.
that you get a
Therefore,
do-over on
that's the next
elections?
general election because there's still 60 minutes left.
No,
No,
so
Your Honor, because the Commonwealth's position is
what
to base the
what this
decision in the
should have
text of the
been
Constitution, which
is
establishes that election day is the election. So anything that
there
that
should
gets
have been
passed must be passed
an
before
election
election day.
in between
We've
this
talked text.
constitutional
What
amendment
about
because
purpose?
that's what they're
So
pushing, a
one
constitutional
argument
amendment.
is
Oh,
we need this
go ahead.
delay so that there's time
Yeah.
for voters to educate themselves for debate, number one. And then number two, so there's accountability. So if the legislature swept on a tide of passion does something that the voters decide is bad, there's the opportunity then to hold them accountable in the next election. So we have text. You've addressed that very well. Help us with the purpose aspect of it.
Sure, Your Honor. The two answers to that, and both are based. Well, you see, going with the purpose reason. One is based in establishing what the purpose really was, and then another based on even if the purpose was as stated, it would not be served by by affirming the court below. So to go to page 498 of the debates, where Delegate French Slaughter expressed the purpose of that provision, there were a few words left out in the respondent's brief, so I want to give the whole quote. He said, "Not only would there be an intervening House of Delegates election where you might be able to get the sentiment of the people on an amendment you had acted on previously, but upon reflection, the General Assembly might decide not to submit the amendment." So that you might get what the people think, and upon reflection, the General Assembly might decide not to submit the amendment. Suggests that there should be some intervening time, and that's the issue, is to provide an intervening time period for the General Assembly to change over to a new General Assembly, maybe hear from constituents, maybe not. But then 2 pages earlier, there's the discussion of the publication requirement and whether there should be a publication requirement. And Mr. Slaughter states in no uncertain terms that the whole reason for removing the publication requirement from before the next general election issue is that the idea is that the people get educated before they vote to ratify it. And so therefore, that is when people need to be educated, is when they actually vote. And so if we're talking purposivism here, if we're talking about the purpose of protecting the people's vote and protecting the people's ability to weigh in, then I feel like it would be patently unfair to override the people's vote because of a concern that they had not gotten to the opportunity to voice their opinion months earlier.
Regarding the special session surviving the convening of a general session, do you have any authority other than constitutional silence?
No, Your Honor, there's no authority one way or the other on it. It really just comes down to the fact that, and there is one thing I do want to correct on the record about that, though. There's a lot of discussion of 611 or 612 days of continuous session. But to be clear, the legislature did business a grand total of 14 days. They were not.
But contends they were in session the entire time. They didn't have to.
What? Oh,
They
that's
didn't have
messed
to
up.
pass a new resolution by a supermajority or have the governor call them
So
back
they
in
were in talks for the
at their
entire time?
option.
No,
And weren't
that's
they
what they're
actually pro
saying,
forma continuing the
but
session?
they
Yeah,
weren't physically
they
there.
recessed the session several times.
Oh,
But the
yeah.
bottom line is, Your Honor, they were actually in session for 14 days. So the
The
talk of
session, the session lasted the entire 2 years. Whether they did business during the session is a different question.
well, perhaps, Your Honor, but the bottom line is there's no reason to start talking about how this legislature created some non-citizen or professional legislature. They were in for 14 days. They didn't violate any concept of a citizen legislature by remaining in recessed session for a long period of time. They only actually did business for 14 days. And so given that, and given the fact that there is no authority one way or the other, but the bottom line is that they weren't converting themselves to a citizen legislature. I really don't think that there's any constitutional argument that they somehow violated their powers as a legislature to continue the session. Unless there are any further questions.
I have one, but I didn't want to eat into your time on the 3 issues that are before us. My understanding is there's additional lawsuits that are working their way through the courts.
Yes, there should
Can you
be.
give us a just very quick update on essentially where those are, if you're able to?
Yes, I am, Your Honor.
Okay, thank you.
There are two other lawsuits working their way through. Currently, one has been filed. The Commonwealth has filed a notice of appeal in the Court of Appeals. This court then certified it to itself. We currently have a motion to expedite that's pending
Right.
and awaiting a ruling on that. There is also a litigation on the compactness of the maps. The Circuit Court of Richmond ruled yesterday that the maps are both compact enough, and the constitutional amendment abrogated the compactness requirement for this anyway. And we have not seen any response to that just yet, but that was yesterday.
Okay,
Was
that's
that a
sounds like bullshit.
final order on the merits or a final order on a request for an injunction?
That was an order on a request for an injunction, Your Honor.
So
this
to the best
guy's
of your
up
knowledge,
for
there's
the
no
whole,
final
yeah,
order
the new
in
maps,
that one.
that is just
That is correct, Your Honor.
fucked.
Yeah.
A lot of balls in
There's
the
a lot
air.
going on,
It's-
yeah.
It's helpful to have
Yeah,
the
they're-
latest on that. So
Well,
thank
They've
you.
been keeping me busy.
We figured you'd be the one who would know.
Fair enough.
Thank you.
All right. Thank you.
Thank you, counsel.
That's interesting. Yeah, this is definitely not going to go away in one ruling, I'm sure. I'm having a feeling that this is probably headed directly into a federal court system. Just because
Okay.
it's... this is just my
Good morning,
guess.
Madam Chief Justice, and may it please the court.
Right.
Thomas McCarthy for the appellees. The Virginia Constitution and Code delineate a very specific and detailed process for amending the Constitution, a process that proceeds in two stages with an important role to be played by the voters of the Commonwealth in each.
That they're trying to
The
run
court held
around.
nearly half a century ago that
Right.
Virginia voters are entitled to strict compliance with that constitutional amendment process.
Yep. Yeah.
Yet a bare partisan majority of the General Assembly rammed the proposed amendment through the legislature,
Yep.
departing radically from the mandated constitutional amendment process and historical practice, severely undermining the rights of Virginia voters, and indeed undermining confidence in the results of the very referendum itself.
When you say a bare partisan majority rammed it through, that sounds like an argument about something that they shouldn't do. But we're only concerned with what they couldn't do. It doesn't matter that it passed by one vote, and if it only passed by one vote in the General Assembly, if they have the power to do it, or if they followed the right procedure. They clearly have the power to do it. The question is, did they follow the right procedures? So I'd
That's
ask
an
that you
interesting
focus your argument
reframing.
on that.
Certainly, Your Honor, as an abstract matter, certainly they have the power. The legislature has vast powers. But for that very reason, Virginians have long distrusted legislative power and feared the tyranny of permanent legislatures, which is why there are strict limits in the Virginia Constitution on when and how the legislature can meet. As I think was noted earlier, our Constitution provides for a citizen legislature. Right? What it does is regular sessions are only once a year, second Wednesday of every January, and only for 30 or 60 days. So the default position is that the legislature is not sitting. There is, of course, also the Constitution provides for special sessions. The governor may convene a special session of the General Assembly in the interest of the Commonwealth when the interest of the Commonwealth may require it. And the governor shall convene a special session upon the application of 2/3 of the members elected to each house. Now, the proposed amendment violates the Constitution's limitations on special sessions in two ways. First, it's the product of an improperly expanded special session. Starting with
Okay,
the
so
text,
that gets that 14-day
sessions are
rolling
special.
cycle that they were talking
That's
about
why
earlier.
a 2/3 majority at each house is required just to assemble the body outside of its normal course. Both Black's Law and the General Assembly's own Legislative Information Service define special sessions as limited to specific issues. Not only that, but both the General Assembly in its application and the governor in calling the special session recited the same limited purpose: to consider budget bills. As noted in our briefing, both Mason's Manual of Legislative Procedure, which, by the way, the Senate uses to construe its rules, and state court precedent construing similar provisions, they say that limiting the scope in this way, as they said that the scope of special sessions is limited to the expressly identified purposes in those calls. The substantive limitation on the scope of special sessions is not just there, it inheres in the very structure of Article 4, Section 6, most particularly in the dual 2/3 requirement. That 2/3 requirement is important. When an application for a special session is proposed, all members of both
But-
houses
But
have.
that doesn't apply if the governor calls it, correct?
I'm sorry.
If the special session is called by the governor, it's a one-person call. He doesn't need
That-
the supermajority in the House. It's if the General Assembly wants to do it, they have to do it by supermajority. If the governor calls it, he just calls it.
That's correct. And this is one that was proposed by application of the General Assembly, so we're in the 2/3 line.
But for an argument that the general necessarily ends a special session, their position is that this is the governor's special session, so we didn't need a supermajority.
Are they going to
address it.
go back and
So
revise
this was
who
certainly not the
actually called it
governor's
now?
Special session. This was the General Assembly special session. They called for it by a joint resolution, HJR 6001. I'm sorry, HJR 4 in April of 2024.
Okay.
They called it. They said it was for budget bills. The governor then responded, as he has to do in the process, and actually calls it. He has to convene it. Then he doesn't have an option. It's not his. It's the General Assembly's. That's why the 2/3 requirement applies. Now, again, the 2/3 requirement is very important. As I was getting to, when an application for a special session is proposed, every single member of each house has the opportunity to approve or disapprove of the issues that are proposed to be taken up, meaning that a minority in either house, right, 1/3 of the body plus one member, can block that proposal. So to allow special sessions to address issues outside of the scope of its application would flout that 2/3 dual house requirement in the special session clause. In other words, HR 6007, which was the first supposed passage of the
Yeah, they're trying to do this
proposed amendment,
retroactively, it
is
looks
invalid
like.
because it's not a budget bill.
Mm-hmm.
Now, there's a narrower argument on the scope of the special session, and this is the one adopted by the Circuit Court, which, by the way, we did not abandon. It's in our brief from pages 17 and 19. We discussed what the Circuit Court did, and we endorse it. The argument is that the special session exceeded its substantive limits as approved by 2/3 of both houses in HJR 6001. HJR 6001 expressly limited a special session to consider certain things, budget bills and 4 other items which are not relevant here, but it was memorial resolutions and judicial appointments, other appointments that required confirmation of the General Assembly, and internal business. But in any event, it definitely did not include a proposed amendment or anything about redistricting. So HJR 6007, again, exceeds that substantive scope.
What does a historical record tell us about the General Assembly taking on additional legislation beyond the stated purposes originally? I mean, is there a historical track record, one way or the other, of this being an established pattern, or is this completely unprecedented, or what?
Well,
This
as
could
far
be
as we can tell,
interesting.
it's unprecedented. And petitioners do not cite a single occasion where a special session went outside of its bounds in this manner. And not only that, they certainly don't have any judicial precedent that endorses that.
All
So
right.
we think what there is an unbroken historical practice of doing what we say is required by
Because
the
that can inform the reading of a text.
Yes,
when
absolutely. Certainly, text, structure, history, it's all relevant when construing constitutional provisions, especially when you're talking about a long history like this is.
Is the resolution for a special session that we're talking about, is it a purely legislative act? Why isn't it fair to allow them to the General Assembly to interpret its own rules and procedures if it's a purely legislative act with no other branch involved?
But if
Well, it's not simply
involves
a
the
purely
people.
legislative act in the sense that there is this 2/3 requirement in the Constitution, right? That's a meaningful. That's where the substantive limitation
So
on
who's the
special
guy
sessions
speaking now, then?
inheres in that.
I
Right, for this very
need to
reason
double
that,
check.
I guess maybe put it this way:
Okay.
neither HJR 428 nor HJR 6001 would have yielded 2/3 support if a proposed amendment for redistricting were on the table. I don't think anybody would suggest they would have passed. So allowing a bare partisan majority to reconvene that special session and pass HJR 6007 by simple majority absolutely just eviscerates that requirement. It's acting as it's not even there in the Constitution. And I think that this court should not condone or countenance that, especially when the people are ultimately the ones who possess government power. The court said it itself in Staples. The people are the ones who hold the power to amend or modify.
Somebody's
the
a ring
Constitution.
banger.
And that's exactly why this
Hear him
court
pounded on the
Yeah, I
podium.
hear
said
that.
that
Tap,
strict
tap, tap,
compliance
tap.
is required with
Right?
all
Yep.
specified procedures. It didn't say just the ones that are in the Constitution, but all of them, restoring similar provisions. And not only that, but there's an unbroken historical practice just like this. There is no example, and petitioners cannot cite a legitimate one, of a special session that continued to act during a regular session or after a regular session when it started before. The historical practice is that if a regular session adjourns, then you would start a new special session. But again, then you either need the governor to call it out of necessity,
And
or need the General
practically
Assembly out of
speaking,
two-thirds.
once you are in general session, you can take up anything you want.
Exactly. So it really makes
then
no
the
sense.
floor is wide open to do whatever you think you need to do.
Yes,
That's
but this
exactly
is a
right.
special
So it doesn't
session.
even make sense. It's sort of a nonsensical position to say that the special session exists through a regular session, not to mention remaining open in session, maybe not actually on the floor, but for 612 days. Now,
That's a
even aside
hell of
from
a
that,
long
proposed
time.
amendment is void for another reason.
612 days
because
for
there
a
was no intervening
special
election.
session.
Under Article 12, an amendment's second passage must take place after the
612?
next
Did I hear
general
this right?
election of members of
I-
the House of Delegates.
No, I think I misstated that.
Now,
Or
to
I thought it
construe
was
the
like
word election would begin with
112.
ordinary
But
meaning.
now I'm lost.
Webster's, Oxford,
Same.
Black's Law, they all
the
define
droning of
election
the
to
dude
mean
talking,
the entire
it's kinda
process by
difficult
which
to keep
votes are
focus.
cast to determine a winner.
Yeah, he's
There's
very
campaigning,
lawyer.
There's ads, there's
Yeah.
events,
That's what I hate about
there's
it.
ballots being cast.
You need to
So then the
listen,
chief
and
argument in
only
response is
10% of
that
what you
there's a
hear is worth
specific
listening to.
yeah.
Meaning to that, to the Virginia Constitution. So that's the main argument on the other side.
Right.
We have to construe it as a whole.
We certainly do construe legal documents like constitutions as a whole, but I think that petitioners are taking out of context. For number one, as Justice Russell pointed out, it's not even the same word in the House of Delegates and the Senate provisions in the Constitution. It says elected, which is something different. But not only that, but almost every provision they cite, it's about election day or the day of the election. And that is a different term than election itself. Election itself has a meaning. It's known everyday understood meaning is the combined actions of the voters and officials to produce a final selection.
And
that's
speaking
why-
of the historical record, I'm not aware, but I may be mistaken, of an instance where the General Assembly adopted this particular process. In other words, where there's an ongoing, there's voting. I don't want to use the word election, but where there's people are going to the polls to cast their ballot. There's campaigning events going on, pro and con. I'm just not. It's doesn't address a constitutionality per se, but I'm not aware that this process was ever used before. Is that correct?
That's correct. This is unprecedented. This amendment process is unprecedented in several respects.
If this becomes
This is just
precedent,
one of them.
then
This
the
meaning of
whole
election
Virginia
is
State
consistent
Constitution
with
is
the common usage of the
up
term.
for
It's consistent
grabs.
with how courts use it. I mean,
Oh,
in
no.
one of the
Yeah,
preeminent
that's
election cases
ultimately
from
what
the US Supreme
happens
Court,
when you
Foster
get
versus Love,
cases
the
like
Supreme
this,
Court said
where they just want to
that,
just
the
redo
defined
everything
election is
just
the
for their
combined actions
one
of voters and officials to mean-
process.
to make a
It
final
all just
selection
goes
of an
out the
officer.
window.
Right.
The Fourth Circuit recently in Pierce versus North Carolina
Yeah,
Board
if
of
you start
Elections
pulling too many
said
pins,
the
it all
election
comes
was happening
crashing down.
right now
Yep.
because early voting in person had already started.
The fulcrum on which the next general election argument turns, as I take it, there's no real disagreement between the two of you. If voting before election day is part and parcel of the election, if it is participating in the election at the time you win, if it is putting your ballot into cold storage and it doesn't take any significance on until election day, they win. Is that it?
I think there's a little bit more on our side, Your Honor, to be fair, because it's not just the word election. We're fighting over that, but we also have the word next, which means something. Also on our side, I think that the whole purpose is on our side as well. And on that purpose, there was some discussion earlier about the proceedings and the debates of the House on this part of the Constitution, and the point was that it was to get the sentiment of the people. And I think petitioners said something to the effect of, "Well, it only says they might get the sentiment."
What?
That's not to mean that the voters might or might not get the information in time to be able to make a decision in an informed manner. It's about they might or might not express their will through their vote in that election a certain way or another. Voters vote
Yeah.
one way or another for lots of reasons. So they might or might not get the sentiment based on this proposed amendment or that proposed amendment. But 100%, the purpose of this provision is to make sure the voters are informed.
One thought occurred to me on this point, which is it's one thing when you have an ordinary election and there's a swirl of issues, et cetera. But when you're amending the Constitution, that could be for generations to come. Hence the requirement of strict compliance, because it's hard to undo if it turns out to be ill-advised. And so a vote on a with constitutional implications may be different than an ordinary vote on general public policy questions.
Indeed, and that's why it needs to come before the voting begins, so people have an opportunity to exercise that right meaningfully. Take Camilla Simon, one of the plaintiffs in this case. She is a regular Democratic voter. She is in support of nonpartisan gerrymandering, like 2/3 of the Commonwealth. She voted early in the 2025 general for her delegate, Rodney Willett. After that, in the waning days of the election, it was Mr. Willett that introduced this new proposed amendment. And she was very unhappy about this. She wished she could redo her vote, but she couldn't. She was denied the opportunity.
Counsel, did the trial court accept that factual finding?
It did. It was uncontroverted. It was sworn in a verified complaint. And I should note that petitioners had the opportunity to seek discovery or ask for a deposition. They didn't either. So they waived their opportunity, but more to the point, I think they probably waived that opportunity because they knew there was no basis to challenge it. In any event,
Interesting.
she, like a million or more other people, voted before this proposed amendment was ever even proposed. None of these voters had any idea this was coming.
Wow.
And that's not how the process is supposed to work. Because as I mentioned before, it's the people of the Commonwealth, the voters, who possess the power to amend or modify the Constitution. And denying them the knowledge that this proposed amendment is coming through undermines the whole process.
Yep. That's a good point.
Regarding the 30-13 requirement, it's on your opponents have conceded that the steps laid out in 30-13 weren't complied with. But it would strike me, but no remedy is provided for in the statute. It would strike me as pretty extreme for us to say that one rogue circuit court clerk just refusing to post it on a courthouse wall stops the entire Commonwealth from ever considering a constitutional amendment. And that would essentially give a circuit court clerk veto power over amending the Constitution.
No,
Isn't
that's
that
not the
too
point.
extreme given our cases regarding shall as directive rather than mandatory to government officials?
Your Honor, I don't think it is too extreme. And there's a few reasons why. For one, petitioners point out that the rule, the duties that are provided in Section 3013 used to be a part of the Constitution. So they were a part of the Constitution, then they became part of the Code as part of the 1971 amendments. Okay, there's still the law of the land.
Well, right.
And not only that,
there's no question the clerk is supposed to do it. Shall directs them to do it. They must do it. But the question is, if one circuit court clerk, whether to thwart a constitutional amendment or just because they forgets to post it 90 days before, there is no, then the whole rest of the Commonwealth can't amend the Constitution. That seems extreme.
Your Honor, I understand that your hypothetical is kind of an extreme one. Two things.
But it's your position, isn't it?
Well, two things.
Oh, that's putting words in your mouth.
Is that Coleman requires strict compliance to the entire process. But the second is this.
I hate when people do that.
Yeah.
This is
So
not
fucking
a law.
annoying.
So
This isn't
that's
like
the when did
one
you
circuit
stop
clerk
beating
somewhere
your
in the
wife?
Commonwealth only
It's like,
put it up 48
no,
days
that's
ahead of time,
bullshit.
Something like that. It was never posted, ever, anytime.
But strict compliance. One doing it on everybody doing it correctly, and one doing it on day 89 is not strict compliance.
So
So it seems to me you got to buy all of it for you to be right. That one rogue clerk can stop all of it.
Your Honor, I don't think that's the case. Now, although strict compliance is the rule, there may be circumstances like the Raglan case indicated where substantial compliance might be in order, where there is like maybe one clerk who's a couple days late. Because I can promise you, if every other clerk in the state did it, or the Commonwealth, I should say, and somebody forgot, they would know the next day and they'd put it up.
And the point of this, though, is to provide notice to the electorate, right?
That's exactly what it's for, Your Honor.
So we have a lot of cases dealing with statutory harmless error, right? So there's a statute that says, do this, government official, but through neglect, whatever, they didn't do it. And then we say, okay, well, was that harmless? And anyone who's paying the slightest bit of attention to the news cycle knows about this constitutional amendment. So what about the argument that, okay, well, sure, they were supposed to do it, but I mean, leaving to the side the retroactive repeal, but really, I mean, now we get our news through social media, through news outlets, through the internet, through whatever. So would it be harmless? Could it be harmless error?
Certainly not in this situation. First of all, it wasn't inadvertent here. They just did it this way. It wasn't because somebody forgot. And second, it's not harmless at all because of people like Camilla Simon, because there was more than 1 million people who voted before this thing was ever even proposed. This is not like,
yeah, see, that's bullshit.
maybe they did it a couple days late.
That argument goes to the timing, not the failure of the clerk of the House or the clerk of a circuit court to do the steps in 3013. That goes to next general election more so, doesn't it? Because she voted. But
I think it goes to both because the 90-day notice is supposed to be to make sure that the voters are informed and honestly to allow time for campaigning, because that's when a lot of this comes out. I mean, there are lots of voters across the Commonwealth who are not totally educated on all the events going on in Richmond, and they need time. The Commonwealth needs time for the whole thing to be aired out. Yeah. That's the whole point. To get the sentiment of the voters, the information needs to be in the hands of the voters in time for them to make reasoned decisions and to actually vote. And that's what's missing here. And the point I was making to Justice McCullough was really about his harmless error analysis in a way, which is about, okay, what's the actual effect and whether it was inadvertent or not. And I think on that, it doesn't work here. This is a case where it wasn't inadvertent at all. And there's a massive error when over 1 million people vote without this information.
I mean, hell, when one person votes without that information, I consider that a malicious perversion of the process. That's just me, though.
In short, Your Honors, the proposed amendment is invalid for several reasons, any one of which is sufficient to invalidate the proposed amendment and require invalidation of the vote. Before I close, I want to say something about the Commonwealth. It's often said
it's turning into a shithole.
Laws, not of men.
Yep.
Sadly, that's not the case. If a bare partisan majority can circumvent the constitutional amendment process and undermine the rights of the people, in whom all government power ultimately rests. Also, that partisan majority can transform our system from a nonpartisan one where the voters select their representatives into a partisan one where the representatives select their voters.
Yep.
We ask that the court enforce the constitutional amendment process by affirming the decision below, declaring the proposed amendment invalid, and enjoining the certification of the election. Thank you.
Thank you, Counselor.
You know, I bet we both know where this is going,
Rebuttal?
and it's
2
not
minutes and
good.
1 second.
Yeah.
Thank you, Your Honor. So just a few points in reply to establish that the people did, in fact, validly ratify the proposed amendment.
No, we didn't.
Last Tuesday.
No.
First, I want to reiterate the fact that the challenger's sole argument with respect to the scope of business of the special session at which the General Assembly passed the proposed amendment the first time is that they purportedly exercised a power not found in the text of the Constitution to limit the scope of business in that special session. Now, I just want to point out that House Joint Resolution 428, which is when the General Assembly applied to the governor for that special session, says, and I quote, that the business shall be to consider such matters as are provided for in the procedural resolution adopted to govern the conduct of business coming before the special session. So in the document that was voted on by a 2/3 majority, it refers then to the procedural resolution, which the General Assembly then shaped pursuant to its own procedural rules. So for them to win on that point, it has to be the case that the 2/3 majority power refers not just to the convening, but also textually to a power to limit the scope of business, and they have to stack inference upon inference to say that 2/3 majority request did so.
So the General Assembly is the master of its own operations, and if they wanted to close the door more tightly, it could. If it wants to leave it ajar, it can.
Yes, that's correct, and they can change that by majority vote at any time. And so I think
But in other words, if they had a pretty airtight resolution saying we're only going to look at this one thing and absolutely nothing else, then you might agree. And
no, you
would not. Okay.
No,
Of course
so I'm saying
not.
that the
Of
argument
course
fails
not.
for
It's
two
fucking
independent
clowns.
reasons. And the first is that the Constitution
course.
doesn't give the General Assembly to limit business in the first place via that 2/3
All right,
mechanism.
thank you.
Then with my few remaining seconds, I'd like to just refer to federal law. So federal law defines the election as the day of the Tuesday after the first Monday in November. And this goes back to 1872 when they defined the election as the day for that day as the day for the election. The federal cases are unanimous on this. Indeed, the Supreme Court heard a case last month concerning, this is Watson v. RNC, concerning whether ballots that are mail ballots that are received after Election Day are consistent with the federal election day statute, which again states that the day for the election is the second Tuesday in November. And it was conceded, agreed by every single
let's just
party
have
that early
revolving
voting is
elections
consistent
at
with
all
the day of the
times.
election
Fuck it.
taking
Just
place on a single day in November. And
Every
so
time the left loses,
legal
they just
meaning
get
of the
another
word
election
is
until they win again.
unanimously
Also known as
agreed
the
upon
EU way of
to
doing
be a
things.
single
Yeah.
day in November. That defeats their argument. Finally,
No, it
I
doesn't
think
defeat their
that it's
argument,
important
you
to
fucking clown.
recognize that
Counsel,
section.
your time has expired.
Thank you, Your Honor.
Thank you.
no silence,
Court will
fool.
be adjourned.
All right. Well, that's that. That's the special session, which I don't know, Trev. What did you think of that? Because that's
Oh, it's
since you're outside of the U.S. and this is your exposure to our clown show that is the court system.
well, as far as I can tell, it's a bit of a headache. What I can tell, beside all the fucking legalese mumblings that makes me hate courts more than anything else, it's people want to be scummy for the right to be scummy, and they try to cover it up in the thinnest veneer of any kind of help for the civil populace.
Yep.
But you can, with just a little bit of effort, you can clearly hear that this is the excuse here is because I want my team to win and screw the other guys.
Yeah, and granted, there's a part of me that's like that too. But the thing I find very worrying, as a long-term outcome potentially for this, is that they can change a special session to do or mean whatever the hell they want. And
Yeah.
that's dangerous. That is very dangerous long term.
New speak, but on a legal level.
Yeah. And it's also something where if they can expand special sessions that they've called themselves for whatever reason, where's the limits on government? I mean, there's a certain amount of a certain expectation that you should not be able to do whatever the fuck you want at all times for any reason just because you got quote unquote elected to office.
Yeah. Hey, if you want a good example of, just look at Jonas Gahr Støre in Norway.
Yeah.
Yeah.
It's just,
basically what he does on a daily basis, and just blatantly ignoring every kind of thing up any decent human being wants.
Yeah, I think that's just such a bullshit thing, and
yeah,
it well, I can't say I'm shocked that they went this route. I'm just shocked that they didn't think somebody was going to call them out on it. But if this stands without any question, without any court oversight, the Commonwealth of Virginia is done. I mean, as a entity that operates under its own rules, it's done, because this is basically saying, nope, take this, throw it out, fuck you. It's nuts. It's not right. It's not
Literally just making itself a slave to the greater force above it instead of having any sort of ability to decide itself.
well. It's not even that. It won't play by its own rules. It just does whatever is necessary for power.
Yeah. So it becomes the perfect place for the average Democrat politician to be, I hear.
Yes, yes, indeed. And it actually sickens me to a degree that this is really a grave possibility. And it's something that I just think a lot of people either don't know about or didn't care about. And even worse than that, because it's a special election for this amendment, most people weren't even going to go out and vote anyway, especially in mid-April.
Yeah.
Because, when elections are normally in November, with the exception of primaries, and those are set whenever the parties want to set them, this is something that is so out of the ordinary. And when you have voter turnouts like we talked about the other day, where the areas with the most votes only had upper 40s, and the areas that voted no overwhelmingly were in the mid to low 50s. Just imagine if, I don't know, they had a longer period of time to have this debate, rather than just political campaign ads with pro or anti-Obama sloganeering. And it's like, I'm tired of that man being part of a electoral process. But that's regardless.
Yeah.
So yeah, it's very disturbing.
It is.
All right, folks. Well, that was the audio disaster of the Virginia Supreme Court special session. Thanks for those that joined in. It should hopefully have been a little better, but you make mistakes and you forget your settings.
Yeah.
Huzzah.
And sometimes you bring the dude who literally has a tech debuff on, and you suffer the consequences.
Exactly. I blame you, Trim, for my inadequacies.
And I blame you for letting me in.
All right, folks. Well, thanks for tuning in. Trim and I will be on later today on Discordant Dragons. And then there's the Autist Circle on Thursday. Check your local listings if you can figure out what the hell that means. And yes, thanks for stopping in, everybody. And thank you, Trim. You're a good individual to bounce off and edumacate, so the rest of the audience understands too.
I'm glad to be the common man or the idiot.
Yeah.
Depends on what's mood of the day.
You could be the common idiot.
Works too. It still makes me smarter than the average Democrat voter.
At least you figured out what to vote for if you were able to vote in this election.
Exactly.
All right. Thanks, folks.
Well,
bye-bye.
Thank you for letting me join, dude. Bye.